And with that, it's my pleasure to introduce our introducer, Michelle Finity, who is our MC for today. And Michelle, would you like to come up and please introduce our speaker? Thanks.
Thank you. Today we're going to hear a very interesting talk about this book that he has just published. It's very interesting. You can see it's kind of torn, but that's because I take it out all the time and read it, whether I'm in a car or whatever. Not while I'm driving. No. Not at all. Distinguished Professor of Law Michael Vitiello is a nationally recognized expert on criminal law, sentencing policy, and marijuana law. His work on California's three strikes law has been cited by the United States Supreme Court and the California Supreme Court. Since 2002, he has been a member of the American Law Institute, a prestigious independent organization committed to improving and modernizing law, whose highly selective membership is comprised of the best legal minds in the country. Professor Vitiello is the author of 13 books and over 80 law reviews. Prior to entering the Legal Academy in 1977, Professor Vitiello served as a law clerk to a Pennsylvania appellate court judge for 3 years. He earned his BA in Swarthmore and his JD at the University of Pennsylvania. Please join me in welcoming Professor Michael Vitiello.
Thank you so much, Michelle. I wasn't quite sure what the demographic was going to be, but it's nice to see people of my own generation here. Maybe you'll understand a few of my jokes. My students clearly don't. But it's also very nice to have the mother of one of our McGeorge students, a former student, and then a former colleague and his wife in the audience. So it's a little bit of homecoming. I want to start out with just a brief comment about writing the book. Can you hear me okay in the back? Good. So when I was writing the book, I would have various conversations with my wife and with some friends, and I would get a lot of pushback, and I couldn't quite figure out why. And then I realized that in talking about the victims' rights movement, they assumed, because a lot of my book is about criticisms of the movement, that I lacked empathy for victims. And by the end of my remarks, I hope you'll recognize that that's not true. I think the victims' rights movement has done some very good things, often not going far enough, as you'll see. I urge for some reforms that even go further than victims' rights supporters urge. And not only that, defining victims with more empathy than some members of the victims' rights movement. So let me get started by telling you I'm going to do 4 things. First, I'm going to talk a little bit about what the victims' rights movement is. Then I'm going to highlight 3 chapters in my book that I think give you a pretty good arc about what the book is about. One chapter is about victimhood, defining victims. The second is the core, one of the most important aspects of the movement, and that is legislation that they got passed beginning in the 1980s that allows victims to testify during sentencing phases, both in death penalties and in criminal trials generally. And what I want to do in that section is to really level some important criticisms, including the ways in which victim impact statements can skew the death penalty along racial grounds. And then finally, my last discussion is going to focus on a chapter in which I talk about what we really should do if we care about victims. So let me start what the victims' rights movement is. It's somewhat of an amoeba. There is a core that I'll talk about, and that's the law and order wing of it. But the victims' rights movement very often will consist of different groups, single-issue groups like Mothers Against Drunk Driving. They'll work with other members of the victims' rights movement to get single-issue legislation passed. The feminist movement has been important at times, but they have ambivalence very often about the movement because the right wing of the movement focuses on law and order issues, and sometimes the police and prosecutors have not been sympathetic to women's issues. But the core, and what most of my book focuses on for criticism, is the law and order wing of it. starting really in the 1960s, sort of the origin story, if you will. When I was preparing my remarks, I thought I was going to have to explain what the Warren Court was. Good, thanks. Okay. There'll be more time for questions and answers then. Okay. So what happened, the origin of the victims' rights movement dates back to the Warren Court period when, between 1961 and 1969, when the court was expanding criminal defendants' rights, the application of the Bill of Rights to the states as limitations on state power, the exclusionary rule in the Fourth Amendment for illegal seizures. I'll bet everyone here has heard of Miranda versus Arizona. Frank Harrington was a law and order right-wing attorney who really attacked the court, and he is the grandfather, if I guess father, grandfather, we in this group probably grandfather would make sense, of the movement. He attacked the court. He used the kind of rhetoric that Richard Nixon would pick up during the 1968 presidential election. I'll talk more about that in a moment. But Carrington accused the Warren Court of mollycoddling criminals and unfairly attacking the court for increasing crime rates. That's the real origin, although the movement really had a number of other springboards, notably in 1972 when the Supreme Court, for a period of time, outlawed the death penalty as administered in the United States in Furman versus Georgia. That became a really important moment for Carrington. He gained economic support from the Heritage Foundation, wrote a prominent book called The Victims that laid out an agenda to increase victim participation in the criminal justice system. His ultimate moment of power came during the Reagan administration when he became part of the Attorney General's Task Force on Violent Crime. That task force recommended a variety of policy agenda items, some of which got enacted into law, both at the federal level and eventually at the states. The one I'm going to focus on, apart from urging the greater use of the death penalty, the one that I'm going to focus on is victim impact statements at criminal trials. Now, so let me start then by talking about the chapters in the book that I want to focus on. I had an acquisitions editor at NYU Press where the book is published, and she sent out the proposal to some outside evaluators, one of whom recommended that I include a chapter on victims and victimhood. It hadn't occurred to me to include it, but it turned out to be what I think is a chapter worth reading. The chapter begins with a statement by Donald Trump during the post-2020 election, where he claimed that everyone was a victim. And one of the things that you have to recognize is the way in our society now we use victimhood to claim special status. In other words, you should not be able to speak as freely as I am because I am a victim and therefore I have a special platform. One of the things I explore in that chapter is whether seeing oneself as a victim is healthy. And there's a good bit of psychological evidence that it's not. And you can imagine why not. If you go around seeing yourself as a victim, you're not likely to achieve what you're capable of doing. Give you a good example. We have a course on the legal profession where students read a book about the mindset. And I suspect some of you are familiar that successful athletes give themselves positive images that increases their likelihood of success. So I start out again looking at victimhood as unhealthy psychologically as a way in which to see ourselves. And there's a good bit of, as I say, academic literature that supports that. Closely related to, and something I'll get into more that I talk about in that chapter, deals with the way in which who we define as a victim. And later on, when I address that in more detail, you'll see that I define victimhood more broadly than the victims' rights movement does in some areas. Let me move then to the criticisms of victim impacts, excuse me, victim impact statements as administered in our system. The way in which victim impact statements work is that you can come in during a sentencing phase of a criminal trial and testify as someone who is the crime victim or as a family member in a homicide case. And you can talk about the loss that you've experienced. So what's wrong with that? I identify, and today I'm going to talk about three things that I think are largely wrong with the way in which those statements are administered. Start with this. As administered, victim impact statements can violate the most critical fundamental principle of the criminal law. I'll give you a hypothetical, and then I'll expand on it later. Two offenders, identical. They get up in the morning, each one independent of the other. They decide that they're going to go out and shoot the first person that they see. Culpability, identical. One shoots a wealthy white person, the other shoots a homeless person. What's going to happen when somebody makes a victim impact statement at trial? One person is going to get a much more severe sentence than the other, despite the fact the critical factor, culpability of the offender, is identical. Victim impact statements can skew the amount of sentence based on something that is random, not related to underlying culpability. Point one. Point two. There's an active debate about whether the American death penalty system is racially biased. I'm not an empiricist. There are competing arguments about the empirical literature. I'll let you review that. The question is, by the way, I think the weight of academic support is that it does skew on racial grounds. The victim's race, very important. White victims more likely to get the death penalty. Black defendants more likely to get the death penalty. How can victim impact evidence influence whether the death penalty skews along racial grounds? Think about it this way. What we know is, point one, who is the most likely to make victim impact statements in murder cases? So you've got a determination of guilt, typically of the highest degree of murder, first degree murder typically, and then a sentencing hearing. And what we know is white victims are far more likely to make victim impact statements than non-white. So you're going to have more participation by white victims' family members. Point two, we have juries that are whiter than the communities from which they're drawn. Despite the fact that prosecutors are not supposed to use their peremptory challenges along racial grounds, every prosecutor in the country knows how to give a non-discriminatory explanation to exclude black jurors. Now, why would they want to do that? Because they know that whites are more likely to favor the death penalty than blacks do. Simple reality. But what happens then? Why will white victim statements be given more credit by juries than other victims' families? Well, the reality is that white jurors tend to empathize more with white victims than people of color. And so you have a system that builds into it a participation by white families, white educated families more frequently than anyone else, education too, wealth too, whiter juries, and more empathy towards people of your own race, skewing the death penalty. Now, from my perspective, having a death penalty system that skews against people of color simply based on color rather than any level of culpability, to me is a reason to reject it and to reject the use of victim impact statements in that way. there is yeah, if you ever have doubts about what I was just describing, um, I've written about a particular case in a couple of different articles involving a death penalty case. The way the death penalty works, if you're not familiar with it, is prosecutors during the sentencing phase introduce aggravating circumstances, defendants introduce mitigating circumstances. There's a very famous case where there was a 17-year-old killer. Now, it's no longer constitutional to execute people who were only 17, but at the time it was still constitutional. 17-year-old killer killed during a failed carjacking with two adult co-defendants, high school athlete, popular kid, had a local DA come and testify that he had aptitude for rehabilitation, all those mitigating circumstances. Sounds like a case where the death penalty would not be suitable, not among the worst of the worst. What influenced it? Well, there was a very powerful statement by a highly articulate, white former federal judge, Mike Luddick. And in fact, I read my students in my criminal law class, I read them the victim impact statement, and somebody as skeptical about the death penalty as I am. And when I read Mike Luddick's victim impact statement, I'm thinking, shit, I want to vote for the death penalty. Sorry about that. Do I have to bleep that language? All right. Okay. Anyway, so if you have your doubts, I can send you that victim impact statement and see whether you're not inclined when you read it. It's just such powerful stuff. I should add that the perpetrator, the 17-year-old kid, was black, Mike Luddick white, highly educated, highly articulate, and not only was the death penalty imposed, but the defendant was executed. Again, the power of victim impact statements, again, skewing it on grounds that I think are morally inappropriate. Let me talk about one other thing about victim impact statements that I think should raise some questions, and what I talk about in the book. And that is closure. I bet that everyone in this room has heard that if you participate in a criminal trial, if your family members have been killed or that you've been a crime victim, that you will get closure by participating in the criminal trial. I bet every one of you has heard it. No, you haven't heard it? You've heard it. You've heard it, and you've heard it on the news. And so let's peel back whether victim impact statements, victim participation gives victims closure. I would be inclined to say, even if I have some other doubts about victim impact, the use of victim impact statements, that I would be inclined to tilt towards allowing it if it really provided victims the kind of rewards or at least benefits that are promised. You would think that closure is a psychologically recognized term. No, of course, this is an educated, can't get anything over on you. But for most of us, it does. I mean, I know when I talk to people in the media, they sometimes will push back when I say, well, what do you think closure is? It sounds like catharsis. Turns out it is a term that entered the literature in the 1980s. It was a term that was introduced by members of the victims' rights movement in order to explain its policies. So it is a political term, not a term of art. Let's think about whether participating by making a victim impact statement, whether victims are going to get closure. Before we get there, though, I want to take a brief detour for another reason why I'm quite skeptical about whether the reason why we have victim impact statements is to provide victims with closure. The marathon bomber, remember that case? And of course, some families wanted the death penalty. They, of course, were told that by participating, they'd get closure. Some families didn't want the death penalty. And in fact, they said, let's get this over with. We want to have closure. We want this to end. We don't want a 20-year post-conviction nightmare where there are appeals after appeals. Now, I'm not criticizing post-conviction appeals for many reasons, and we can talk about that later. But what did the prosecutor do? The prosecutor made a choice to seek the death penalty. But what about the family that said, we want closure, we don't want the death penalty? They were not going to be called by the prosecutor. So I question at least some prosecutors in telling people, we're doing this to give you closure, because prosecutors are making a choice to seek the death penalty, not to give victims closure. Okay, in the Boston bomber case, there were a lot of different families, so maybe more families wanted the death penalty. Matthew Shepard, do you know that case? Yeah. The family didn't want the death penalty. They wanted closure. Prosecutors said, let's get the death penalty. So again, you've got to ask whether the idea of using victim impact evidence is really about providing victims closure. At least some people, I'm cynical enough to think some people are not in it for giving people closure, but instead for increasing the death penalty. Going back to Frank Carrington, that clearly was one of the reasons why he supported. Yeah.
Wait, no, but we'll take questions at the end.
Yeah. Okay. So then apart from that, apart from closure, let's think about whether victims are going to get closure. And when you actually think about what victims experience, I think the closest diagnosis is post-traumatic stress disorder. Have you read the literature on what the modalities are for treating PTSD? Not a single one of them looks like coming in and looking at your victimizer in an unregulated courtroom setting and thinking that's going to give you psychological healing. Now, it could be part of a larger program, a larger methodology, but certainly the idea that you're telling people that closure will occur ain't going to happen. In fact, many people who participate in the system say, we feel like we were given a script and that we had to testify a certain way. Let me move to my last topic that I wanted to cover, and that's my last chapter on what we do if we really care about victims. I want to talk to you about victims generally. I mentioned that in the chapter on victimhood and victims, I thought that there were a couple of things that I would pick up in this part of my talk. And one of the things I want you to think about, Sandy Hook Elementary. All right. How many victims were there? There were 26 administrators, children. What about the mom? And then think about Adam Lanza, the killer himself. When the killing first occurred, there were local churches that rang 28 bells. Adam, his mom, 26 people at the school. Then, after a while, they stopped ringing one for Adam, and then finally down to 26 because there were criticisms of the mom that she was an enabler by trying to reach out to her son and get involved in going to gun ranges with him. I want you to think a little bit about whether you think about a case like that as a battle between good and evil. I don't. I think that if we lack the empathy to realize, read about Adam Lanza and his deep, profound psychological illness, what a deeply troubled childhood he was through no fault of his own. And people are not clear exactly what rendered him so profoundly mentally ill. What about his mom? Was she an enabler? Some of us who have had children who were not perfect, didn't do everything well, may have had some psychological issues. Every parent who has suffered with a child who has suffered mental illness knows that you would do almost anything to help your child. And yet the way in which many people look at people like Adam and his mother have completely lack empathy. I don't see the people who are involved in criminal activity in many instances as evil in the sense of good versus evil, who are really making those kinds of choices. So again, as we move into this, I want you to start thinking a little bit more globally about victim and victims. And so here I want to transition then to another example where I think we need to think more broadly about who victims are. Domestic violence. Women who are, and again, they're men too who are victims of spousal abuse, but the typical, more stereotypical is an abusing man and an abused woman. And we know the pattern in cases like that there'll be a complaint made, and then when it comes to trial, a woman will not participate further for various reasons, some of which are quite rational. She'll lose her financial support if she loses her spouse. She does not qualify. One of the things of the victims' rights movement, I should add, before I talk about what will happen to her. One of the things that is a considerable success is expanding funding for victims of crimes. The funding varies from state to state. It's not uniform, and it may not be adequate, but there are funds for people who are victims to get psychological and medical help. A woman who, though, does not testify, does not participate in the criminal proceedings, loses the opportunity for support. And yet, as we know, many women in that position will be suffering from a recognized syndrome, battered woman syndrome. So my first positive solution for dealing with, if we really care about victims, would be to have a really effective national healthcare system, a universal system, a vigorous system with adequate psychological care and medical care. Obviously, if someone is a crime victim, that's what they need. It's hit or miss now, depending on the state, depending on the size of the fund, and a good national health care system would guarantee that everyone who is a crime victim would have adequate care. But it goes further, much further. Anybody who has looked closely at criminal justice cases, especially death penalty cases, knows something about victimizers. Nobody in this room would change your life for someone who ends up on death row. Not just because you end up on death row, but because of the kind of abuse that people who end up on death row have suffered as children. Extraordinary. I've done a little bit of death penalty work, mostly helping out other people, never handling a case on my own. Didn't have the bandwidth, but you read the profiles, the profound suffering that children have of physical abuse, psychological abuse, neglect. So if we had a first-rate healthcare system, you would have fewer victimizers, because coming into the system, those people would get help and in many instances not go on to become victimizers. That's one positive reform program that would build on something that the victims' rights movement did in recognizing the need for psychological help for victims. But an expanded system would produce, I think, ultimately profound results. Then finally, I'm going to touch the third rail, gun control. Although I'm not sure in a crowd like this whether the Second Amendment is, I'm not sure how many of you, I know a couple probably are going to flash your NRA badges. Probably my old friend Ron over there is going to. Did you do a weapons pat down before you came in? There are, so again, well, I should tell you, I should put this in context. I wrote the first draft of my book and submitted it to some readers, including a very close friend of mine. And he pointed out that I needed to revise the last chapter because I'd written it and it was somewhat rosy. I said, well, you know, there's a real chance that meaningful gun regulation can be passed in this country. Yeah, I know. Hmm?
That's Mexico.
Goods to
Pass
Mexico.
guns to Mexico.
Oh, so But anyway, so what had happened, because it was a period of time where even though the Supreme Court had decided the Heller case in 2008, states were putting in place some meaningful gun regulation. And there was such popular support for some meaningful gun regulation. I mean, the polls are overwhelming in support of meaningful gun regulation. But then my friend pointed out that the Supreme Court had just decided the Bruin case, which makes it extremely difficult for states to pass meaningful gun regulation. But how would that help meaningful gun regulation? Well, there are some debates about the extent to which meaningful gun regulation creates fewer victims. In my book, I review a lot of those studies. Again, I'm not an empiricist, but certainly there's plenty of evidence that gun regulation results in fewer deaths. Guns are a whole lot more effective than any other method of killing. And in fact, if you compare gun deaths, I should say homicides in the United States and European countries with meaningful gun regulation, the crime rates are not that dissimilar, but homicide rates are much higher in the United States. Why? Availability of guns. But I want to go one step further, and then I'll close and take some questions. And that is another way in which to think of victims more broadly. The gun violence, I should add one area where we do know that gun violence would reduce the total number of deaths, and that's in domestic violence. I mean, women in the home, women are killed frequently and more easily with a gun than any other weapon. Will they die by other means? Of course, but it's a whole lot easier to die from a gunshot wound. But the one thing I wanted to close on, and it's not a very positive note because again, I think all of us are not all that optimistic about gun regulation, and that is to think about suicide. We tend not to think about suicide victims as crime victims, but I urge a broader understanding of victimhood by greater empathy for our fellow human beings and also the families of suicides. And one of the things you have to recognize, and some of you probably do, is there are more people who die by suicide with guns than there are homicide victims. And so if we had meaningful gun regulation, we would have far fewer people suffering from the kinds of harms done by guns. Thank you.
Okay, if you have a question, just raise your hand. Mike will bring the mic around to you. They started?
Professor Vitiello, the victim impact statements from what I'm am seeing you're implying are a political tool.
Can be.
If these DAs want to
Certainly in some instances.
want the judge to hear them or not. I was going to ask you about the other use of them, and that is in restorative justice.
Okay. Restorative justice is a great topic. Could I defer that for a moment? Because I just realized there was a point I wanted to make about victim impact statements in non-capital cases. Whether victim impact statements really skew sentences in the non-capital area is debatable. It's open to a lot of debate how much influence they have, and there's a reason for that, why they may not have it that much of an impact, say in your ordinary run-of-the-mill robbery or other violent crimes. Typically, there'll be guideline systems in place that limit the amount of discretion that a court may have. And then there are also so many cases are done by plea bargains. And so judges are going to be very hesitant to overturn a plea bargain because they'll lose the advantage of that. I should have pointed out too, this is in my notes and I didn't get to this point, that a lot of other victim rights movements, legislation like three strikes laws have bloated our prisons and have not provided the kind of protection that we need. I mean, there's a poor use of dollars. Now, restorative justice. I'm sure that many of you probably know about restorative justice. Well, there are specialized programs where, for example, a crime victim can set up, there'll be some kind of mediator in that context where the victim can talk directly to her victimizer. And sometimes that does produce successful results. I do talk a little bit about restorative justice in my book, and the reason why I give it only small coverage, it remains a niche in our system. It is a very highly specialized area. It's not generally available. There are some very encouraging results there. There are some data that do support that restorative justice does work. It probably works best where the victimizer is stupid rather than criminal. In other words, can any of us remember being 15 years old? I mean, a few of you can. I mean, I remember that thin line between, I don't think I was ever criminal, but I certainly was stupid in a kind of immorally immature way. And so it probably works best in those kinds of situations. So I do know it has some good results. Will it ever take over in the United States? Almost certainly not. There's one other thing I do worry about restorative justice, and that is if you have it widely available, are you pressuring victims into participating? That's one risk. There's another risk. Will people of different races, will people of different races be willing to participate cross-racial, or will it be another way in which we continue to have racial disparity in the criminal justice system?
Very short follow-up. In the context that I've seen it, the Native American courts do it. If the victim, and I'm not going to use victimizer, I'm going to use the word offender.
Yeah.
If the victim has been harmed, the offender is educated when they hear it.
Yeah.
And if the victim isn't in a position to talk or give the statement, then the community tells the offender, this is not acceptable. This is how you can restore. And you're still a member of the community.
Sure.
That's the whole point.
Yeah. Well, and again, when we're talking about small, isolated groups, highly, I mean, that's again going to remain a niche. And it is a fascinating model. It is. Yeah. Other questions?
I have a question. Yeah. Mike, can I have the mic?
Too many damn mics around here.
Thank you. And I don't know anything about this subject, so my naivety is here. So one thing you talked about the victim statement, and maybe they don't want to have that person be up for the death penalty.
Yeah.
But the prosecutor wants to push it anyway.
Yeah.
So first thing I was thinking, well, what's the advantage to the prosecutor? Why, other than, and why does he care that much?
About the death penalty?
Death penalty. That's one question. And the other one was, what's the process of the victim statements? Like, do they have a time period, or they say you can get up and talk for 5 minutes or an hour?
Okay.
Or,
Yeah. Okay. So first, I should tell you one thing. I did work in a prosecutor's office for a year when I was a law student through my last year at law school, and had a couple of opportunities had I not been able to get a clerkship and then get into the academy. So I've also worked on the other side of the aisle as well, just so that it is not just beating up on prosecutors. One of the things I learned when I was in a prosecutor's office in Philadelphia, Pennsylvania, was that there are really different kind of prosecutors. There are some people who really had a very high sense of their obligation to the criminal justice system, who were not athletes, if you will, people out to win. And don't forget, although in this area maybe you can run as a prosecutor smart on crime, most of the time prosecutors win by being tough on crime. In fact, I don't know who you voted for in the last Sacramento DA's race. I live in Yolo, so uh, I didn't get to vote, but there was a softer candidate who lost, and even in a county like Sacramento. So prosecutors tend to be, they're playing to the public, and in many areas, it's very seldom that prosecutors run on any other platform than Tough on Crime. It's happened a little bit in recent years. It happened in Philadelphia, for example, quite recently, with mixed results on whether mainline prosecutors fall in line with their new boss, who has a different perception. So the general, I'm up for reelection. I want to brag to my constituency that I got so many death penalties. And we know now that the death penalty is being applied in fewer and fewer cases, and we know where they tend to be. They tend to be in a state like California. They would tend to be in the more law and order counties, San Bernardino and Kern, and then in the United States South. In fact, there's an execution either today or tomorrow, and just happened. South Carolina, yeah, by firing squad, yeah. So yeah, but in other words, very few prosecutors who are running for office run on a platform that I'm going to oppose the death penalty. It can happen. Yeah.
Part of the question.
Oh,
What's the mechanism?
oh, the mechanism. Well, it'll vary. Courts have a lot of discretion about it. Yeah, I mean, you don't have fixed rules about it. Yeah.
So the question up there?
Yeah, by the way, if you'd like to see an example, Chris, email me and I can send you an example. In fact, I can send you an article that it's funny. I did a symposium piece for a Brazilian symposium on the victims' rights movement. And I talk a lot about the Luddick case I was describing. And it was a funny kind of thing. It's just a little bit of an aside. They were honoring a professor who was retiring, who had been a very strong advocate for the victims' rights movement. And I felt like that cranky uncle who you invite over at Thanksgiving and then hope the hell he doesn't say something too offensive. But anyway, I can send you that, and it describes the way in which these can work. Yeah.
So back 30 years ago, when I was taking college courses, I was informed that it costs us a lot more to give the death penalty.
It does.
Than it does
It does.
50 years in prison.
It does. It does.
And when I try to explain it to people about the required number of appeals that you have to be allowed,
yeah.
Can you explain that?
Sure, sure. So, yeah. There are some states where they try to speed up the death penalty process, but basically states control only part of the death penalty. So let's assume we're in some of the states like Texas or, well, I'm trying to think of another very quick state where you can get to from conviction to execution fairly quickly. Those states can speed it up under state law. But then there's federal law that allows you, if there's a federal issue in the case, constitutional violation typically, you can then get post-conviction relief by filing eventually in federal district court for post-conviction relief. Writ of habeas corpus, although it's more technical than that. And so then you move through the federal system. And then there may be additional allegations, because if you've moved through the system, you may then turn around and contend that the representation that you've got is ineffective. Sure. So delay. And it's quite interesting, a quite interesting debate. Justice Scalia said that we have never executed anybody who was innocent. I mean, it was, yeah. The people who are really honest about it say, well, if we're going to have the death penalty, we'll make mistakes, but that's, all systems are flawed. But interesting discussion about, and again, empirical data that probably are not true. There's one empiricist who claims that for every execution, we save 18 lives. Now, don't worry about it. It's almost certainly not true. In fact, Cass Sunstein, very prominent criminal constitutional law scholar, published an article where he talked about how if those data were true, we would have a moral obligation to support the death penalty. But of course, the article was not about his support of those data. But when you look at how if you're going to have the death penalty and make it effective, you have to do it quickly, shortly after the person has been convicted. Now, if you're trying to protect against innocent people being executed, then you can't have a quick execution. So the more you start to trying to balance values about why we have the death penalty, the more difficult it is to get any deterrent bang, if there is any deterrent bang from the death penalty. So that's one reason why. And then, of course, providing adequate counsel. Many years ago in I want to say 1998 or thereabouts, we organized a program for a group of new death penalty advocates. The state, when Ron George was the Chief Justice of the State Supreme Court, wanted to have better representation for people on death row. Prosecutors wanted the process speeded up. And we got a grant to run a program at McGeorge to try to do training for a group of lawyers. And when you saw the workload, that each attorney could handle basically one new case a year, because when you looked at the files in these cases, they were enormous. You basically, for a death penalty trial, you need 2 attorneys. And the reason you need 2 attorneys is one person's going to try the guilt phase. And then after that person loses, that person now has to get up off the ground and defend bring in evidence in the sentencing phase. Extremely difficult. And then, by the way, if you believe in adequate counsel, you want to provide people with adequate counsel. Does anybody want to have people executed because they didn't have adequate counsel? I didn't think so. But then if you have people with adequate counsel, then the death penalty is not likely to be imposed. You remember the killer in Aurora, Colorado? The movie, he trapped people in and killed a bunch of people. I mean, you talk about someone who would seemingly be eligible for the death penalty. He had a remarkably competent set of attorneys and was spared the death penalty. Anyway, but it's not a huge part of my book, but I've written a lot about and thought a lot about the death penalty. And, you know, it's funny, I guess I'm an agnostic about the death penalty. I live in Loyola County, and back in 2005, I needed hip surgery. I was in a lot of pain. I got a jury notification, and it was a death penalty case. And I really wanted to serve. And I knew I had a ton of excuses. I also knew how to fill out the 20-page form if I didn't want to serve. I could have said I was absolutely opposed to the death penalty. And I didn't say that. You know, would I vote for executing Adolf Eichmann? I don't know. I might. Adolf Hitler? I might. So I'm an agnostic about the death penalty, but for so many reasons, I'd be hard pressed.
I have just 2 quick questions.
Please.
The first one is, because I think it was just last night, about the gentleman that was going to be executed by
Firing squad.
firing squad. I thought, and this must have been, at some point, the Supreme Court had said that was unusual, cruel punishment. So I didn't know that they still do that.
I'm not aware if they ever held that using the firing squad was. I don't know. I know that they've had a lot of cases where you could challenge the method of execution.
Right.
It might be that now, because in South Carolina, there were 3 choices. I think medical injection, electric chair, and firing squad. So that might have been the way in which they were able to do it. Here, it's your choice.
Oh, so he had the choice.
He had the choice.
Okay.
Yeah, he had the choice.
And
So
then my second question is, you know, the Melendez brothers, there's that
Yeah.
big debate going on.
Yeah.
Are they going to use impact victim statements, do you believe, in this phase of their?
Well, there's an
case?
interesting thing. Their aunt wants them out. Yeah. So in theory, no. I think that there are legal challenges there. I think that the basic legal challenge was whether the evidence was excluded that should have been allowed, basically of parental victimization, sexual abuse by the father. I think I think it's a technically legal issue at this point, but I'm not sure. But I do know apparently the aunt thinks they've been in prison enough.
Hi, thank you for all this great knowledge. I'm not sure how to frame this up, but I'm not a psychologist,
Nor am I.
but I've been to a lot of therapy. Okay.
Welcome to
Yeah,
my.
there you go. I got,
You know, I think in this crowd,
yeah.
we could probably fund a scholar, an endowed share if we all gave up the money we've used
you
in
go.
therapy.
Okay, so for the issues that I had as a child, trauma, if you will, I know that therapy is not a one and done.
No, of course
It's
not.
a process.
Of course.
It can be a lengthy process, which
very.
requires a lot of guidance.
That's right, and the
So-
right therapist.
Yeah. Okay. So I struggle with this notion of closure, quote,
Yeah.
closure,
Oh,
that
absolutely.
someone's going to attain closure simply by witnessing, or attending the trial and seeing somebody assigned the death penalty.
Yeah.
Is there any valid psychological studies done on this idea
Yes.
of closure
Yes.
based on simply attending?
Yes.
Can you say some more about that?
Yes. Yeah, and again, this is one of those really fascinating areas in the literature that there are some competing studies, but, and you know what I'm next going to say, the well-designed studies. Yeah, but I do talk about them in the book. If you really want to follow up, I can give you some citations. But it does look like the best studies suggest that no, it does not. I mean, for the reasons you and I have just established, absolutely the idea. And then you look at the treatment modalities for PTSD. Yeah, no, it's
So the pushing the closure as a prosecutor
yeah,
is invalid.
I think so. Now, I have to be very careful. We just did a symposium 2 weeks ago. I helped organize it. McGeorge has had for 40 years a victims' rights clinic. In fact, we were very prominent. Gordon Shaber got one started, our dean, for 34 years. And we've had people really helping victims. So I have to be very careful. And we brought in a lot of very high-powered people on the other side of the issue to talk about these questions. And so there really is a vigorous debate about all of this. But look, I do think that the people who are victims' rights advocates, and there are advocates who will talk to victims, and they do tell them that they're going to get benefits by this. I'm going to assume, I bet that they're genuinely convinced of it. I don't want to question their motive. Certainly, I try not to question their motive in that regard. And they probably, I would imagine, here's what I would imagine would happen. Someone has testified, and the victims, the DA and the victims' rights advocate leave the courtroom, and the person says, "Wow, thank you so much." They feel great, and the person goes home, and a few days or a few weeks later, feels like crap again. So, I mean, again, I'm not questioning the good faith of everybody who disagrees with me. I think that was one of the great things about our symposium, and what academic institutions and institutions like this are doing is to get people who may not agree with one another talking in intelligent ways, or hopefully intelligent ways, about their differences. But I think you're giving false counsel. Let me tell you one of the really difficult areas. I know this from talking to a woman who does this work out at UC Davis. We all, I think, agree probably that there is a need for more reporting of sexual assault. And this woman, when I was giving a presentation like this, said, "I've got to tell victims that they're going to get something out of it by coming forward. That's a tough one. You know, it's, you see what a moral dilemma that is.
I think I have time for one more question back in the back.
So do you have any suggestions about, the death penalty costs so much money
It does.
that even if we left out all the moral part against it, it
Yeah.
just doesn't make any sense
know.
to do it. Do you have ideas about why people hang on to it and what we could do to change it?
Well, put it this way, my ideas about trying to change it haven't succeeded because I've been writing again about the death penalty for a couple of decades now. So you want to take anything I say with a grain of salt because it hasn't worked. Education does something, but look, think about it this way. If you're talking to somebody who has a profound belief in good and evil, that crime and crime victims, good victims, evil doers, and if that's our view of human nature, it's very hard to get them to move off square one. I mean, it's got a kind of religious fervor to it. Even if it's not a religious belief, there are people who profoundly believe that the death penalty deters. And some of them are very intelligent people. And I mean, I've participated in debates with people who have really good ideas. They're just wrong.
Professor Vitiello, thank you so much. This was really great, very enlightening, very unusual topic for this group. And as a token of our appreciation, and you're our age group, we're giving you an honorary membership in our Renaissance Society. And we are also making a contribution in your honor to the Seth Nelson Emergency Cares Fund, which goes to help students who experience emergency needs, such as a car breaks down or something like that. So thank you very, very much. This was great.